This is Local Edition. I'm Brad Pomerance in our Capitol Bureau in Sacramento. We are joined by Sharon Runner. She is a member of the California State Senate. And I'd like to take us back to the year 2006. You were very involved in a campaign for a proposition known as Prop 83. What was Prop 83?
Well, we named it Jessica's Law.
Right.
It was basically based on something that happened in Florida with a sex offender living across the street, took a young child, Jessica, who was 9, raped, murdered her.
We remember.
Yes.
Yeah, a tragedy like
yes,
another.
Yes. So my husband and I decided to
George Runner, who's now on the BOE.
Yes, and we couldn't get the bills through the legislature, so we took it to the people. It passed by 71% of the vote of the people of California.
And what the proposition says
was it restricted, well, there were a lot of points to it,
for
a
our
lot of
purposes
different
today.
balls, yes. But it restricted living where sex offenders could live 2,000 feet away from a park or a school.
Right.
So that's what the people voted for. They didn't want their children to be walking by a sex offender's home on the way to school or at a park,
Right.
and that's what it did.
And so, very simply, once a sex offender was released,
Yes.
finished their sentence,
Yes.
Prop 83, like you said, indicated that no parolee of a sex offense could live within 2,000 feet
Yes.
of a park or school.
Yes.
Done. So, about 9 years later, a case percolates through the system to the California Supreme Court, known as the Taylor case.
Yes.
And in that case, out of San Diego County, the applicant was indicating that he couldn't find anywhere to live
In San Diego.
in San Diego County
Right.
that satisfied the 2,000 feet restriction. The California Supreme Court ruled unanimously that
that was true in San Diego County, and they then allowed him to live within 2,000 feet
Right.
of a school or a
they
park.
said, as it relates to San Diego County,
Yes.
Prop 83 was unconstitutional.
Only San Diego County.
And that's that's the key, because what ultimately happened then is the Department of Corrections turned to the Attorney General, the state Attorney General, and asked, do you believe that this case that came out of San Diego County has applicability in all 58 counties? And she said,
Yes.
Yes.
And I think it was a little more opposite, that the Attorney General said, you guys need to apply this to the whole state. We haven't seen a memo, but according to the CDCR, California Department of Corrections and Rehabilitation, the memo came from the Attorney General that this is what you do. You need to apply it to the rest
and
of
it's
the
interesting
state.
because you have sought to have that memo released to look at the legal analysis.
We've asked for a letter.
Right.
We've asked for all kinds of information from the Attorney General's office to say, where do you in law see this happen? And we've had no response.
What we've heard is that the client, Department of Corrections, is claiming that the Attorney General, there's that attorney-client privilege. I'm not commenting
Yes,
on it,
right.
but that's what they're claiming.
Absolutely.
Yeah. So here we are today, and we do know that even under that case, the Taylor case, that restrictions can be placed on these sex offenders. But recently, the Associated Press did an analysis. And the
CDCR,
thank you, CDCR,
California Department of Corrections and
had
Rehabilitation,
said they thought that under the analysis of the Attorney General, that about 50% of those offenders would fall out of the restriction because of the 2,000 feet.
Living 2,000 feet away from a school or a park.
But what did the AP find out?
The story was amazing. They found out there's only 76% of those sex offenders
Have fallen, yeah.
have fallen into that category and are out. Only 24% are still within that 2,000 foot range.
And so what we've learned, Senator, is that I guess 5,900 parolees would have Prop 83 apply to them, but 4,200 are falling out of the restriction because of the determination that in retailer, they can't tailor a location for them to live.
Right, which is, in certain parts and certain counties is just unbelievable because there are places for them to live, especially for people in my district. You know, we have a huge community. I represent Victor Valley, Antelope Valley, and Santa Clarita Valley, and there are places for people to live there.
And I remember, I think it was last year, former Assemblymember Steve Fox was on the air talking about the pillowcase rapist.
Yes, and, who lives out in Lake LA.
Right, and that caused a tremendous amount of angst. And I guess
in the community.
And in the end, was he placed?
I believe he was still placed out in Lake Los Angeles.
And this case, the Taylor case, was implicated.
And he was 2,000 feet away from a school or a park.
He
fit in that category.
He did, okay.
Yes.
So arguably good news.
And Lake Los Angeles is not populated very well.
I understand.
It's a very small community. So there's a lot of places that aren't near a school or a park.
Here's one element that I do want to ask you about, and I think it's an interesting wrinkle. When Prop 83 was in full force, before the case was decided by the Supreme Court, there was a significant issue with homelessness surrounding the parolees because they couldn't comply with
certain areas, only in certain areas in the state.
And so, look,
San Francisco, of course.
Right. So I'm sure. I mean, like, I'm sure you're compassionate and you understand that this was a significant problem. Since the Taylor case, many of them have found homes. So how do you balance? Because look, I can't imagine we want parolees, you know,
sleeping under. Yes.
Because that only makes them more likely.
Worse.
Yeah, it makes it worse.
Right.
So talk to me about the balance, Senator.
Well, you know, I really believe that there are places for them to live. They just chose not to. The homeless population. You know, so I don't think they were all homeless because there are places for them to live. They just ended up choosing, and like a lot of homeless people, they don't want to live somewhere. They want to live, you know, under the bridge or wherever they feel safe.
So you have tried to find a legislative remedy because, as we know, under the law, if there's a decision of the court, the legislature can come back, and as long as it's within constitutional framework, amend and try to, I guess, reverse that decision.
Yes.
And so you submitted in the last session a piece of legislation, SB 54 it was called, that was looking to allow for further review of an appellate division as opposed to just the Department of Corrections making a determination.
Right.
And looking at clarifying how the 2,000 feet could be measured, limiting the Jessica law restriction to only violent sex offenders.
Yes.
And so talk to me about what happened with SB 54.
Well, initially, you know, when we saw this case, of course, we immediately wanted to respond. We believe that each county should make that decision.
Interesting.
Not have to go to a court, in the Supreme Court. That there is something called an appellate court in each county that if they couldn't live within that restriction, they could go to that appellate court and they could make that decision. So it was a simple, easy fix to the other 57 counties that could allow or disallow based on this appellate judge. I think it's a three-person appellate judge in each county.
The bill died.
Yes,
where do you
immediately.
Go? In our final moments, where do you go from here?
Well, I've introduced the bill again.
Okay.
Again, changing some of the restrictions as far as 2,000 feet as the crow flies. You know, versus, you know, there may be a huge ravine or something between the two. So I have introduced it again. We'll see what happens this time.
And you'll come.
But I have all this information now from the AP story.
You'll come back and tell us more?
Absolutely.
She is Sharon Runner, member of the California State Senate. I'm Brad Pomerance in Sacramento, local edition.